Patna Prasad Singh versus the state of Bihar. This was appealed.
But the appellant before your lordship, my lord, was initially appointed in the year 1985. Initially, he was appointed in 1985 on daily wages, my lord, as an assistant, my lord, under the my lord, leprosy abolition scheme, my lord. And thereafter, I was regularized, my lord, in 13/8/86 by Annexure 3 in the writ application, my lord. I was regularized against the sanctioned post, my lord. Having worked for about 18 years, my lord, and during that period also, my lord, inquiry was held, my lord, with regard to my, my lord, the mode of appointment and the, my lord, validity of the appointment, my lord. And thereafter, my lord, I was started, my lord, being given the salary and all, my lord. I enjoyed everything at par with the regular employees, my lord. Now thereafter, my lord, inquiry was held, my lord, again on pursuant to the order of this honourable court. A number of persons were, my lord, appointed against, my lord, class 3 and class 4 post, my lord. An inquiry was made. Now thereafter, my lord, the first inquiry, my lord, it was held to be irregular. If your lordship will kindly have a look, my lord, there were 3 inquiries held, my lord. The last inquiry was a one-man committee, my lord, headed by Honourable Mr. Justice Uday Sinha, as he then was, my lord. Now, in that inquiry, my lord, main thing was not taken into consideration that the 2 inquiry reports, earlier inquiry report, in one I was shown to be irregular, my lord. And the other one, my lord, I was shown to be, my lord, illegal appointee, my lord. Now, the Annexure 24, which was in the writ application, my lord, which I have shown to your lordship on the last occasion, my lord.
How many things had happened?
Lordship. Yes, it has a bit checkered history, my lord. It has
lost in flood, fire, or stolen. Records. So many things happened.
Yes.
Flood, fire.
But the thing is, my lord, I worked for, these are the admitted fact, my lord. I worked for 18 years, my lord. And lord, the others who were identically appointed, my lord,
Order of appointment.
My lord, the order of, my lord, Annexure 3 is my lord, order of absorption, my lord.
No, where is the initial appointment?
My initial appointment, my lord, on daily wage basis, my lord. There was no such appointment letter given at that point of time, my lord. There was a master roll prepared. So, your lordship, my lord, had, my lord, already directed the counsel for the state, my lord, to obtain the records of this case. My point only arises for one, my lord, one consideration for your lordship, my lord. My lord, the 2 inquiry report, my lord, was, my lord, it was dichotomous, my lord, with regard to each other, my lord, with regard to irregular and illegal, my lord. And that was not taken note of by the honourable, the one-man commission, my lord.
Yes, in terms of directions of responsibility. Adjusted.
Number of one Ratan Kumar Sinha is there, my lord. Although my writ application is mentioned there, my lord. And I was held to be irregular, my lord. And in the next inquiry, my lord, I was... Lord, my instructing counsel is also somewhere, my lord. So only one thing which falls for your lordship's kind consideration in this LPA is, my lord, the earlier 2, my lord, the contradictory, my lord, the inquiry report. In one, it was held, my appointment was irregular. And the other, it was held illegal, my lord, without disclosing why it is illegal, my lord.
So as on the date of your absorption,
My lord.
in terms of Annexure 3, what was the scheme of regularization? What was the policy of the state government? Where is that?
The scheme of regularization I have not brought on the record, my lord.
Without that, how?
But that is
right.
That was never an issue, my lord.
They are asking you.
Huh.
We are going to the root of the matter. First of all, whether you are entitled for regularization.
Regularization
or not.
240 days, my lord, was the only criteria, my lord. 240 days,
That means you are
my lord. Because one thing your lordship will appreciate, my lord, admittedly, I worked for 18 years, my lord. And lord, that showed, my lord,
Were you subjected to selection process?
in the office of civil surgeon, my lord, Saharsa, I was appointed on the basis of, my lord, the
Political
advertisement.
Political appointment.
It was not, my lord, it can be termed, my lord, by your lordship, my lord, but certainly not a political, because persons of these grades
Show us the selection process.
political, my lord.
All right, show us the selection process. If it is not political, show us the selection process that you are subjected to selection process.
Since that was, my lord, this leprosy abolition program was, my lord, a program which was set in motion, my lord, which needed, my lord,
So,
immediate.
sir, your right existed reference to Annexure 3. Annexure 3.
My rights stands crystallized, my lord, after having worked for 18 years, after having undergone a number of inquiries, and thereafter my salary was started being.
What has said that if initial appointment is bad, you are not entitled to any relief.
But the thing is, my lord, why the baby only? Why not the bathtub, my lord? The person who had made the appointment, my lord, he should be also chucked out, my lord.
He must have. He may not be alive.
No, he may not
He
be.
may not be alive. I mean, most of these type
Lord,
of cases, the officers who issued order of appointment, they will not be in service or they will not be in the world.
Hands are not fettered. Hands of the state is not that fettered, my lord. To identically,
Show us the right.
both the baby and the bathtub.
All right, sir, show your right that you are entitled.
My right, my lord, has crystallized now, my lord. It has crystallized on account of my having worked, my lord, for 18 years, my lord. And, my lord, no, this objection was raised by any person, my lord, at any point of time. Inquiries were held, my lord, with regard to the payment of salary. And after having been found, my lord, my appointment was genuine and valid, thereafter, my lord, they resumed to give me the salary. My lord.
Your initial appointment itself is bad.
All these things.
Because Annexure A3, you have a statutory right that I am entitled to regularization.
As a daily wage earner, my lord, I was a.
All right, sir, show us for daily wage regularization. There are a number of schemes.
My lord, we cannot ask them to, my lord, to run on our diktat, my lord.
Then we can't help. Anything else?
But this is the only thing for your kind consideration.
In the instant petition,
This is the.
sorry, appellant has asserted the order of the land single judge.
It is.
23rd August 2000.
23/8/18, my lord. Order dated 23/8/18.
(23/8, 2018).
Lordship.
Passed in CWJC 17172 of 2010.
Ji.
Yes, sir. The petitioner asks for the following relief. Petitioner services have been terminated on 11/10/2004 on the score that his initial appointment was not in accordance with law. So in other words, he was not subjected to process of selection and appointment. So, Land Council, next Land Council for the appellant submitted that appellant was appointed as a daily wager under the leprosy abolition program. So, his services were stated to have been observed on 13/8/1986 by Annexure 3. Annexure 3 reads as under. The Land Council for the appellant could not apprise this court. Such absorption or regularization of appellant's services is not supported by any material information like any state government policy relating to absorption / regularization of daily wages who have rendered number of years of service, etc. Full stop. His absorption against clerk post was within 1 year from the date of his initial appointment on daily wage basis. Full stop. Therefore, one has to draw inference that his initial appointment was not in accordance with any statutory provision or a statutory scheme. Full stop. Apex Court recently in the case of so and so held that if the initial appointment is a bad and such appointment was not after due selection process, in that event such appointment is illegal and contrary to provisions of constitutional provision. Full stop. In view of these facts and circumstances, no interference is called for insofar as the order of the learned single judge dated 23/8/2018 passed in CWJC 17172 of 2010 NPS stand dismissed.